I had to play around with the sound. Sorry if I'm like 15 seconds late. Anyway, good morning to everybody. Let's see who's here this morning. Again, my most loyal follower is Mr. StreamYard. He's always here. The one belt belted cows. I like that's interesting. Gator Bay, John, White Horse, Alan. Interesting spelling of Alan. My middle name's Alan with a different spelling, Alan. Scott, Dustin, Market Watcher, Tim, Lee, Willis. Everybody, good morning. Hope you are all doing well. I was going to give you obviously an update about a response to the most recent inquiries regarding GTII. Probably a bad time to not be nice to Mr. Hoffman. I think I would just throw it out there. If any of you have seen that movie Airplane, which I have seen, in there, and part of it, they keep on saying, I don't remember, I think it was Leslie Nielsen or Bridges, keeps on saying it's a bad week to have given up, smoking cocaine as he's going through the trials and tribulations of trying to save the plane from crashing. And he keeps on doing these with all kinds of it was a bad week to give up sniffing glue, that kind of stuff. So last Wednesday, my wife got rear-ended on the freeway. She was basically stopped. Somebody on the on-ramp came up the on-ramp and literally rear-ended her going like 40 miles an hour. Luckily, the Subaru, which she was in, did its job. And even though it was totaled, she ended up walking away. She's like sore and has various issues, but nothing, as it could have been. So that's how last Wednesday night started. So I come with a little bit of an edge, let's say, because of that and having to deal with insurance companies, having to deal with people who don't have adequate insurance, etc., and having, the threat of, my wife having lost her, literally, she could have lost her life in that collision. So I don't think it was a good time for people to F with me. Somebody decided to do that, and we'll go into it and I'll explain. Now, whatever I'm saying here today is just my opinion, speculation, etc. You could take it for whatever it's worth. You can include whatever biases I have. It doesn't mean that the receiver and the receivers counsel won't be successful at whatever they're doing. None of that. It just means that I think we have to watch things more carefully is really what the point is. And just to kind of start it off, before I started off, I always approach these people with the following. I say, if you want to tell me something in confidence, I will not disclose it. The only way I will disclose it, for example, if I'm watching out, like in this matter, looking out for GTI shareholders, and maybe the receivers counsel said, okay, I'll share information with you. You will not communicate it until after this is all done or whatever, or not at all. And we'll do it that way. And you can kind of keep an eye on us, and we can find out what's going on, and you can reassure shareholders, etc. That would have been fine. And I always volunteer that. And I try to get that to be the state of affairs, because that way I know more and I can feel more comfort or discomfort and express that to you guys. My relationship with plaintiff's counsel, who filed the original action, was such like that. I could communicate with them, and they might tell me information that I shouldn't disclose, and I wouldn't disclose, except if I found that was not in the best interest, or at least I thought it was not in the best interest of shareholders. The Receivers Council views this differently, and it has become problematic, let's say, over time. I tried to communicate with them multiple times to set up a mutually beneficial relationship. That's part of it also. They don't appreciate the fact of how they got there in the first place. They believe they're responsible for getting things to the point it is now. They don't understand that. And again, it's not meant to brag. This is just meant to put things in context and why someone might be irritated by them. They don't understand how the receiver got appointed and what the process was, nor do they care. nor do they particularly, and again, this is my view, nor do they particularly care about shareholders. They care more about the receiver. I don't think they have any interest in shareholders per se. I don't think the receiver has any interest in the shareholders per se, but his job kind of coincides with the interests of shareholders to some degree. So we're on the same page that way. So that was the pre-joke, by the way. Now, for those of you who come for the humor portion of the live stream, let's go there, and then I'll go back and start ripping. Okay, I've heard of the speed of light, but what's the speed of dark? Does anybody know what the actual speed of dark is? And I know, I hope some of you even know what the word means, but how many of you out there believe in psychokinesis? Please raise my hand. That's a joke, by the way. Depression is merely anger without any enthusiasm. And a day without sunshine is like night. And last but not least, support your local bacteria. That's the only culture most people have. Okay, so let's get into it. I got tired of just what I thought was just kind of not being transparent as they could with the receiver's counsel. The receiver doesn't communicate, at least as far as I can tell, the receiver doesn't communicate at all. To me, might communicate to other people, but not to me. And I've obviously reached out at times. And again, he wouldn't be in his place but for me. He wouldn't have got there. And so be it. And I try to communicate issues and interests to the receiver's counsel. Most of the time, they don't respond, or the responses are non-responsive. But that's kind of the way it goes. And does that mean that they can't do a good job? It doesn't mean that. It just means that it makes me uncomfortable when I don't know what specifically is going on. I know that the receiver's counsel is getting paid out of the estate, out of the assets of GTII. I know that the receiver's counsel is not engaged in any real litigation, no depositions, no lawsuit filed against Justine Reichman, no Liz Pendens. I think a very passive approach. And they've still generated large legal bills. So that's concerning. And the way they've generated the large legal bills is also concerning in my guesstimate. And I've asked the receiver to produce the invoices. I don't know if they will or will not. Wouldn't be surprised if they refuse. That won't give me additional comfort. Again, that doesn't relate to the ultimate outcome. Just relates to this interaction and perhaps what we're getting charged for, what services are being provided, is it the best choice, best strategy, etc. And if necessary, I'll take it beyond that, requesting additional information. So I've asked a bunch of times, and obviously I put out a bunch of tweets because I had enough. I put out a bunch of tweets, and no response, by the way. And then I think I put out something yesterday, and shareholders do send me things. GTI shareholders, other shareholders do send me things at times. And yesterday, and I'm not going to say his name unless he wants me to say his name, but somebody sent me an email response. So the last few days, I was throwing out questions or statements and no response. So instead of responding to me in any fashion, what they did is they responded to another shareholder. And again, my opinion, and they pretended like they were responding to prior inquiries. So let me explain what that means. So on August the 12th, the way it looks like from here, the receiver responded to a shareholder's question. And the questions basically was, what's going on with GTII? Any news on GTII? So, the way this is being presented is it's a response just to a simple question, what's going on GTII? And the receiver is being very fast in responding to this question, because it looks like, if you look at this, on August 12th, 2025, this gentleman who's a shareholder at 11:16 a.m. sends out a email to the receiver, and at 2:36 p.m. on the same day, the receiver, quote unquote, sends back a response. Now, interestingly enough, on the response CC'd are a bunch of lawyers from the receiver's counsel. Interesting. So the way this is being presented is the receiver is quickly responding to an inquiry of the shareholder, except if you look, and again, this kind of nonsense not only annoys me, but makes the creator of this document look deceptive. And we're looking for transparency. So the first kind of, and again, I haven't even gotten to the content, just looking at, and I spent like 10 minutes yesterday looking at this. I bet you if I spent 2 hours, I could do if you recall, JR and I had Trento Mine people on. And do you remember how much those guys sweat after that session? I think if I had enough time and the attorneys were willing to come on and I could question them as to just the issues that I'm raising, that they'd be sweating a lot too. Just my opinion. I don't know. Maybe they wouldn't be, but just my opinion. So why do I think this is not being responsive, super responsive? Because if you look at the very same email, I said August 12th, 2025, 11:16 a.m. is when the shareholder asked the question. Well, underneath that is another question from July 31st, 2025. And beneath that is another question, July 21st, 2025. And below that is another question, July 10th, 2025. And below there is another question, July 8th, 2025. And below that is another question, July 2nd, 2025. Below that is another question, June 18th, 25. Below that is another question, May 2025. As far as I know, there was never any answers to any of those, certainly not any substantive answers. Certainly nothing's been shared with me. So it appears that basically, as if I'm to read this email as it's stated, because I would expect to see responses somewhere if there was, looks like for 3 months they didn't respond to anything. Then I called them out, and then they pretend to respond to this shareholder like it's in the normal course of events. I find that deceptive and bullshit, to call it out. Now, second of all, this is from Paul Strickland. But if I looked at it for 10 seconds, I could tell, it's my opinion, and I'm going to read from it. So, you can draw your own conclusions. But if I spend 10 seconds on this, I can tell this was drafted by counsel, not by Mr. Strickland. And clearly, it's an attempt to respond to my many inquiries that I made over the weekend. Now, I don't think it's responsive at all. I think it's just more blather, but clearly an attempt to respond to my inquiries, but doing it in a manner to appear like it's being responsive to a shareholder and in a timely manner. Again, I think it's bullshit and deceptive. And again, I'm going to call these guys out. Everything they do that is not kosher in my mind, I'm just going to give you my opinion. They can counter it. They could say what they believe or what their intention was or not, or the receiver could speak up. So I see this document and it appears to be from the receiver, and I look at the language and clearly it's not. So it's from the counsel, not from the receiver. Counsel's probably charging us for this also, to explain why they haven't responded. And why, besides the language, why do I think that this is generated by counsel? Because I think it was either the third or fourth receiver's report. This was at a time where I was still trying to make nice with the receiver's counsel, despite their complete and continuing disrespect, in my opinion, of course. I had a communication with with Dylan Siciliano, and during that time, he explained that he was writing that report, and it was like a 41-page report, not the receiver. He was writing to it. And can you imagine how much money we were charged for a report that the receiver could not write? I have no idea, but that's one of the reasons I want to see the invoice. And that was directly communicated to me by Mr. Siciliano. So I don't know if he drafted the prior reports. I don't know if they've charged us for the prior reports. I don't know if the receiver is not capable of drafting a report, and maybe that's why he hasn't posted. I do not know. But the fact that I was told that the attorney had drafted the report, and then I see the language in here and the timing of it, that's what makes me feel, with a relative level of comfort, that this wasn't drafted by Strickland, that it was drafted by the attorney. Could be wrong, but kind of that combination leads me to believe, again, trying to suggest that this is from the receiver when it's really not. Maybe it was provided on behalf of the receiver. That would be accurate. It's not signed by anybody. But again, this is suggestion. It's being provided by the receiver who's interested and knows what's going on, but it's not. Or at least in my opinion, it's not. Now they go through and they explain in here, and again, I'm just going to read one paragraph, and then you can decide if this is drafted by the receiver or by an attorney. And this is a fairly short response, it's less than, it's like a page long. So even though it took them 4 hours to prepare a page on behalf of the receiver. But it says, as you are aware, Global Tech Industries Group, Inc., parentheses, GTII, or the company, close parentheses, is currently being operated in an equity receivership, and Mr. Paul Strickland has been appointed by the court as the receiver. Oh, that's interesting. So I'm going to stop it there. I didn't even notice that. So they're talking about Strickland in the third person. So if something's drafted by me, I don't refer to me by my name. So if a letter is coming from Richard Hoffman, I don't in the letter refer to Richard Hoffman. I say I. So I didn't even notice that, but it's funny. They couldn't even keep it consistent. They're referring to him in the third person, even though it's purportedly from him. I'm going to continue on. An equity receivership is a court-supervised process intended to preserve and manage the company's assets fairly and impartially while addressing financial and operational challenges. The receiver serves a neutral role focused on protecting the interest of all stakeholders. Now, I believe that he has an obligation to protect all stakeholders. Whether he's doing that and whether he's neutral, I don't know. That I can't say. But he certainly has an obligation. But the way it's been communicated to us to this point in time, I couldn't comment whether he's performed his role as it's required here and as he stated. As noted in the court's order appointing receiver, parentheses, receivership order, the receiver shall be the agent of this court, and solely the agent of the court is acting as receiver under this order. So I looked at that paragraph and immediately, and maybe you have a different conclusion. I looked at that paragraph, and besides it's just a BS paragraph, do we not know this or the receivership? Is that in the dispute? Does that help us? Does that provide clarity to anything? Does that talk about the audit? Does that talk about the status of things? No, it's just a paragraph because maybe there was a short amount of time to write this, or they had it from another document, they could copy it. But clearly, the thing I can tell, it's not written by the receiver. That's the way they put the parentheses and that it's clearly not from in my mind, not from the receiver, and it's clearly from counsel. The next paragraph, as I continue, to ensure fairness and uniformity, the receiver communicates all material information through formal receivership reports filed with the court, parentheses, the receiver's interim reports, which I've already indicated, counsel at least drafted the 40 some page report, because that's what he told me, and through the company's SEC filing. So here, what they're saying is that only material information they're communicating is through the reports, which have been, there have been reports drafted by counsel apparently, but they haven't been frequent. They've been a lot of documents and probably a big charge from counsel. But they say here that all material information is communicated that way. All right. So this letter, email, by definition, is not material, right? So they're saying, because they can't, that this response doesn't contain anything of substance. Because if it did, they couldn't send it, because that's what they're saying. They can only do it through the report or the SEC filings. So in the very email they sent, deceptively suggesting they were responding immediately to a inquiry from a shareholder, in it they say, but this response doesn't contain any material information, so whatever. I find that kind of disconcerting, troubling, again, deceptive. They're being responsive without being responsive, and telling you that in the very document. Now, again, not everybody's going to be looking at it as critically as I, and they might think that somebody might look at it and not, may not understand what I'm asserting now. And maybe they think that will be sufficient to move the ball and to satisfy shareholders, etc. Maybe that's what they think. Okay, that's what they think. This approach, I'm continuing to read from this non-material email purportedly sent by the receiver. This approach is designed to avoid providing incomplete information or creating expectations that may not be met. And again, I would say, so I'm going to stop there. I would say that not providing sufficient information creates uncertainty and creates expectations that are governed by that uncertainty, and creates disharmony among shareholders, creates concern about the agents who are purportedly representing the company. So that's the flip side of their approach. They're saying is by withholding information, that keeps uncertainty down. I would say it's the direct opposite. And again, I invited from the day one for the receiver as counselor to come on the program. They elected not to, and they've elected not to communicate. That's their choice. I don't understand why. I should be fair. They have communicated at times, but nothing of a material nature, and basically in a disrespectful manner. That's the approach they chose. I don't know if it's everybody from the firm of counsel for the receivership, but certainly it's at least one, and that person, that's the way it goes. Accordingly, I'll continue. Further, while not all shareholders can trade shares, shares are still trading. Now, again, I brought that to the attention of the receiver long time ago, and I asked them to intervene and find out what was going on. I think I communicated it to plaintiff's counsel, but I probably communicated directly to the receiver's counsel, or it was communicated to the receiver's counsel. And I asked them to intervene to stop the trading if others could trade. As far as I know, they've done nothing. So here they're saying that it can trade. Why? Why don't you contact the exchange? Why don't you contact the transfer agents? Why not? What's stopping you? What's stopping you from filing action? Why didn't you do that in the past? You were able to lock up all the shares of the bad guys, per se, or the shenanigan makers. Why didn't you try to stop trading? If it's trading, and I know it trades very low volume, I certainly can't trade it and will not trade it until it's tradable. In other words, I have shares, but I'm not going to trade it until it's tradable for everyone. I believe, and I hope, demand that because I know that the receiver, as part of his compensation, has already received some amount of shares, and I don't think he's sold any of them, but I demand he doesn't sell any of them. And to the extent that this company becomes tradable, I think he should be concerned about trading them at any point in time, close in time to the point when the stock is tradable, because maybe he'd be trading on non-public material information. And I think it would be kind of improper for him to sell close in time to when it's trading, because he's obviously he and his counsel are aware of inside information that are not disclosing to us because they say they can't. So certainly the receiver can't trade these shares, and certainly can't trade them when they're tradable, at least for some time when the information is not public. Anyway, just my two thoughts there. Accordingly, now I'm back to this wonderful reply drafted by the receiver. Accordingly, it is important to avoid sharing information about the timing of potential uplisting or resumption of trading that could give certain shareholders an unfair advantage. Well, you're saying that people are already trading it. So don't those people have an unfair advantage? And isn't that an advantage over everybody else who can't trade it? So that makes absolutely no sense. And there's obviously information that can be disclosed, because they do here, that can be provided in a clearer fashion, like we expect the audit to be completed in the next 60 days, 90 days. The fact that an audit's completed doesn't tell you the content, doesn't tell you when something's going to trade. Theoretically, if you believe that, then somebody who has access to trading the stock today should buy it today. Because if there's going to be an audit, they might as well front run that. So this purported reason for not sharing information makes no sense, and in effect gives an advantage to people that are currently trading, and gave no explanation or no information why the receiver's counsel did not try to intervene to stop it from trading, period. Next paragraph. And when I see this, I almost puke. Next paragraph. First sentence. Transparency remains a priority. Now, that is the biggest crock. Amongst the BS in this entire one-page email response, that is the biggest crock. Transparency obviously is not a priority. And this email is evidence of it. In fact, it says we can't be transparent because we can't give you information that we deem material. So again, on its face, this is just nonsense, not accurate. And again, an attempt to placate shareholders. They probably got so many inquiries from shareholders that it did its job of getting them off their ass to at least be responsive, or at least theoretically be responsive. I can't imagine they didn't think I was going to respond to this, that I would just they would throw it out and it would just go and it would be accepted. Continuing on. Oh, let me stop for a second. No, so because it's going to come up in the body of this document. One of the tweets that I put out over the weekend, I think it was over the weekend, pretty sure it was over the weekend, and it was to the receiver. My real concern is that the GTII-Receiver and his counsel will so deplete the resources of GTII that no suitor will do a deal with them, and that they will be the only beneficiaries. That would certainly not be in the best interest of real shareholders. I don't know who's going to argue with that statement, but it's interesting because I think it's addressed, and they tried to set up a defense to that, I think, in here. I'll let you decide on your own. Okay. Continuing from this glorious email response that they got out right away to the shareholder, drafted by the receiver, quote unquote. The receiver has filed multiple receivers' interim reports providing updates on the status of the receivership. I'm going to stop there. Interesting, they say he has filed. They didn't say he prepared. That's probably intentional because it wouldn't be true. And because he didn't, because the receiver's counsel told me at least one he prepared. So No, it's interesting the language that was using. It's kind of suggests that the receiver prepared the reports, but it doesn't say that specifically, just says he filed them. Again, if you want to claim that's deceptive, somebody might claim that's deceptive. Doesn't necessarily mean anything about I keep on repeating this because it's important to keep in mind. I'm like ripping this apart. Doesn't mean that the outcome can't still be good. It just means that you gotta watch all this stuff. You can't just rely upon people acting as your agent. You gotta be on top of them because otherwise, just like, the mediation, and I haven't gotten there yet, just like their decision on the mediation not to have anybody present, they said it's up to the business judgment of the receiver. Maybe so. The business judgment of the receiver could be to have somebody from a shareholder there to attend. There was nothing about negotiating, and you're going to hear it coming up, but certainly to attend subject to a confidentiality, certainly that could be done. So that's just more nonsense, lack of transparency. But anyway, continuing on, the receiver has also requested court approval of a process to freeze and claw back shares that may have been improperly obtained. And that is correct. They made up a process and it's been modified. Whatever, I think what they suggested at first changed, and it's now not that. And they went to the mediation, I think, and so they were able to. They've clawed back some shares and they've frozen some shares. The court is okay. Now continuing on, the court has approved the freezing of disputed shares on an interim basis and is yet to approve the process for dealing with the frozen shares. So about 175 million shares have been frozen, but there's been no process set up how to deal with those frozen shares at this point in time. I don't know when they intend to do that. I don't know what the delay is in asking for the court to set up the process. They haven't provided any excuse for not doing that. There may be some strategy that they're thinking about but haven't disclosed. Their choice. However, continuing, please understand that due process is a critical consideration in this matter, and shares cannot simply be canceled without appropriate legal and equitable processes and review. So I'm going to put this in context. Yeah, you got to have due process, so it's got to be notice and opportunity to be heard from guys that the receiver or the receiver's counsel, in 4 lengthy reports that we've been charged probably hundreds of thousands of dollars on, has set forth myriad of situations where the parties that they're referring to have engaged in gross shenanigans. And again, I'm being nice about that terminology. And this is out of the reports of the receiver. So the fact that he's claiming that there has to be, that it requires the specific language, appropriate legal and equitable process. To be honest, the appropriate legal and equitable process would be to put senior management in jail. That would be the appropriate, in my view. My view, based upon the receiver's reports and the shenanigans that he claims that senior management has engaged in, then if he's correct, that's at least fraudulent misconduct. If he's correct, it goes way beyond that. So when they use the term equitable processes and review, that's completely inappropriate. To get equity, and this is just kind of like if you go to law school, first year law student, to get equity. So this is kind of outside. If you have this is not like a contract. This is where the court can intervene and there's no real certainty of a remedy or a claim, but they can make justice happen. Let's just say that. But to get justice, you have to have clean hands. You couldn't have engaged in misconduct. So when somebody uses the term equitable processes, completely misses the boat, doesn't understand, doesn't properly, and I found this to be the case. I don't think they properly value the misconduct that the receiver claims that exists. It's like somebody drafts something, but they don't absorb the information. So they draft this document with no passion and no enthusiasm and no internal ability to grasp what's going on. So then they use these words that are completely inappropriate. The only ones that are entitled to equitable process should be the shareholders who've been screwed by these guys. And again, language, that's not language of a receiver. So to the extent this purports to be from a receiver, the receiver, as far as I know, is not a lawyer, is not going to be using terms like appropriate legal and equitable processes. Again, nonsense, deceptive, just, is what it is. Shareholders affected by this process will have an opportunity to present their defenses. So, I think this is referring to the shareholders they're having mediation with at this point in time. And they're saying, to the extent that we claim that you ripped us off, you could say that you didn't rip us off. Okay, that's fine. However, that should have been done, in my view, day one. Once the receiver was appointed based upon alleged misconduct as stated by the receiver should have sought permission and not wasted legal fees on other avenues, other reports. Should have gone right after these guys. Should have sought discovery, force Reichman to be deposed, force him to either answer or take the fifth, expose them and expose everybody associated with them, not wait, draft reports, and piss away money. That should have been the way it goes. And that was expressed, by the way. That was also expressed about with Justine Reichman, because everybody knew, back to, so we're now in 2025, late 23, 24. I hear from everybody. It's not like a unique concept. I hear from everybody that David Reichman's weak spot is Justine Reichman and that she has liability. I hear it from everybody. I communicate that. So this is like news, not news. It's like public information. I saw it in the LA Times. It's a joke, but it's obvious. And I told our counsel, and our counsel being plaintiff's counsel, and they didn't disagree. And then I kept on inquiring why the receiver's counsel had not sued Justine Reichman in California, had not tried to pursue to get a lis pendens against the property. Recently asked them to indicate what about a writ of attachment, which is a way of securing property that's under in a lawsuit where you think you'll be able to prevail. To this point in time, nothing. No lawsuit, no lis pendens, no writ of attachment, no nothing. And the attorneys who represent the receiver are licensed in California. So it's not even a case where they can't practice in California. They're licensed in California, or at least that's what their website says. I think the attorneys involved in this case are all licensed in California. So nothing stopped them from filing that lawsuit from day one based upon what the receiver claimed in his reports. I go back to that the whole time. I'm not basing this on what I say. This is based upon what the receiver says in his reports, which means that's what counsel thinks that's happening here. So counsel, who drafted the reports, for whatever reason, has still not filed an action against Justine Reichman to this day. No explanation, makes no sense, and in my eyes, was poor strategy from day one. And it's not like it wasn't communicated, because it certainly was on multiple times. So, don't understand that. Had never been explained. Why no depositions to date? I was talking about like day one, like a year ago or whatever it was. A lot of time has passed since then. So again, we paid money. We being shareholders of GTII, I don't really give a crap, by the way, about the money. Because, if the money's spent and we advance and we get this trading again and you guys can get out and everybody ends up with a smile on their face, that's great. But it's the strategy and what that brings, the dollars it's bringing in and the time that's wasted. And again, this is the part I don't get. Wow, this is the longest rant I could ever expect. But this is the part I don't get. There's, like 150 pages of reports outlining all kinds of misconduct that the receiver thinks there's adequate evidence to support it. Yet they're acting like it's the other side that has the leverage, like they do. And from day one, they have acted with such passivity, despite the fact that, according to the receiver, the facts and evidence were all in our favor. So that kind of strategic move makes no sense and is, and again, my opinion, patently ineffective, wasteful, non-productive, whatever other adjective you want to add. No explanation, by the way, at any point in time for why they didn't file a lawsuit in California to this date. Can someone argue that was malpractice? I mean, when I spoke, by the way, whether it is malpractice or not, I don't know, because I don't know. I don't have all the, since they haven't shared it, I don't have all the background. But I've asked that question, by the way. I have asked that question. I asked the question, is not filing a lawsuit against Justine Reichman and potentially exposing the real property that should be GTII's and not pressing, could that be conceived as potential malpractice? I think yes, but I don't know enough to make that conclusion. And if everything works out, it's kind of a no harm, no foul. Doesn't make a difference. It's only if things don't work out where that becomes more relevant. But I brought that up, months ago, the issue of malpractice by not doing that. But people could have different styles, different intentions. They could take different avenues of getting there. Maybe they didn't want to they didn't want to sue Justine because they had a deal in place and she was going to turn over the shares, or something else. That didn't happen, by the way. But maybe there was something in place. But that doesn't excuse them from not today doing that. By the way, just think about this. So we've gone now about 40 minutes. 42 minutes on a one-page email I'm about half done with. And so this is by the way, in a deposition, this is what you would do. I'd pull out this email and I would just read and ask questions. And I could probably do this for 2 hours on this one page. But that's what happens. So continuing on to this email prepared by, quote unquote, the receiver, regarding, okay, let me just make sure I do a complete sentence. Oh, it is a complete sentence. Regarding the company's future, including the possibility of a merger or other transactions, the receiver is in negotiations with AI-Versity's attorneys regarding certain modifications AI-Versity seeks to the disclosed merger transaction. Let me stop there. Am I aware of ongoing discussions? Yes, I am aware of ongoing discussions. Am I involved in the ongoing discussions? No. No, I'm not. Am I concerned by the language that they're trying to cover their ass by suggesting that if the AI-Versity deal does not work, it's because of certain modifications asked by AI-Versity? Do I think they're trying to cover their butt? Yes. Does that language cause me concern? Yes. Do I trust their language? No. So when I saw that, that caught my attention. That was a way of kind of maybe prematurely shifting the burden of why a deal might not work, and caught my attention. John Forster, I'm not involved with him obviously on a day-by-day basis, but he's been more than open to speaking and communicating. That's not been the case with the receiver and the receiver's counsel. You could judge accordingly. What you find is more credible. Somebody who does communicate or somebody who doesn't communicate, notwithstanding whatever nonsensical reason they give for not doing it. Okay, continuing on. And the receiver, careful, let me back up so it makes a little sense. The receiver is in negotiations with AI-Versity's attorneys regarding certain modifications. AI-Versity seeks to the disclosed merger transaction, and the receiver carefully evaluates all options in light of the company's current financial position. I'm going to stop there, where it's the current financial position. Now I'm going to go back to I'm going to read that email or the tweet I put out over the weekend. My real concern is that the GTII receiver and his counsel will so deplete the resources of GTI that no suitor would deal with them and that they will be the only beneficiaries. That would certainly not be in the best interest of real shareholders. So when I see that, and the receiver carefully evaluates all options in light of the company's current financial position, the current financial position in part is determined by the actions to date of the receiver and the receiver's counsel. And my concern expressed by my tweet was just that they would deplete the assets. And here, where they're referencing the current financial position, that to me appears to be their efforts to address that and try to again cover their butt to the extent that they waste or use or dispose of all of the money. And that would probably be mostly in legal fees, I'm guessing, legal and accounting fees, but mostly legal fees. And legal fees that, to this point in time, as a shareholder, it's progress, but nothing to show for it. Progress, but nothing to show for it. So with this language, if the deal with AI-versity does not happen, the way it's set forth, I will believe it's not because of AI-versity. I will believe it's because of the receiver and the receiver's counsel. That would be my guess, my opinion, my speculation based upon my dealings with them and the language used and my interactions with all the parties. So my ability to judge the credibility of the interactions and what they've been disclosed to me. Continuing on. This is fun, by the way. I'm enjoying this. As reflected in the receiver's interim reports, again, I know that Dylan Siciliano prepared, as he, maybe he didn't prepare it, but he told me he did, prepared at least one of them. I'm guessing more than one of them. And it was the 40-plus page report, because he mentioned that at the time. Because I was asking where the report, because it was late, and that's how it came up. I asked them, I was bitching because they hadn't filed a report, and they were late and slow, and I probably asked multiple times, and then he got a hold of me and said he was going to get it out. And then he kind of, he said, it's very long, and it's taken a lot of time. And then when I looked at it, there were a bunch of mistakes in it anyway. I remember that. Now it kind of refreshes my recollection. Okay. But anyway, the language makes me concerned and not very trustworthy. And by the way, none of this, by the way, I should be clear about this. I can't trade this, nor would I trade it, nor am I recommending anybody trade it, nor is this any kind of financial advice. This is background on the legal stuff and not even about what's the final conclusion. This is just my recollections, opinions, representations, thoughts about how the legal side is being handled. It has nothing to do with the ultimate outcome. It has to do with how it's being done, questions about how money is being spent, tactics, etc. That's different. So this is certainly not financial advice, not legal advice, of course, either. It's just my opinion. And I'm not a Nevada lawyer either, and this is happening in Nevada. So, people have asked me questions. I won't respond to a question to ask me whether, buy, sell, whatever, because again, this is not, I don't think this has anything to do with the financial part of the issue here, at least at this point in time. So that's my statement on that. Continuing on, as reflected, and we got like 2 more paragraphs of this brilliantly crafted immediate response drafted by the receiver, quote unquote. As reflected in the receiver's interim reports, GTII has minimal assets and faces significant challenges that makes its future prospects uncertain. So again, remember my tweet over the weekend. I'm going to repeat it one more time. My concern is that the GTI receiver and his counsel will so deplete the resources of GTI that no suitor will do a deal with them and that they will be the only beneficiaries. That would certainly not be in the best interest of real shareholders. And here they're saying, as reflected in the receiver's interim reports, GTI has minimal assets and faces significant challenges that makes its future prospects uncertain. Part of the reasons why there is minimal assets is because how they've been disposed of, in the way they've been disposed of by the receiver. So they've brought in money, but they've spent a significant amount of money. And my My objection would be, if it works out, I have no objection, honestly. If the receiver is ultimately successful, I would never recommend him again. I wouldn't. This is my view. I, obviously don't have nice things to say about the receiver's counsel. And I certainly, if somebody came to me for a recommendation, it wouldn't be my first choice. But if all goes well and it works, then it works. So it's kind of like, the results will speak for themselves. But you can't just sit there quietly and just accept the outcome. You have an opportunity to participate in shaping the outcome. That's kind of what we're doing here. All right. But when they talk about here, the significant challenges that make its future prospects uncertain, part of those challenges, I believe, is the way they're conducting these efforts, the slow pace, the lack of aggression as to the GTI management. That's just my view, and I think it's also a response to my tweet, an attempt to cover their butt if they spend all the money and it doesn't work out. That's what that looks like to me. And again, that they claim that's drafted by the receiver. I doubt, question that, don't believe it, etc. But I could be wrong. But whatever. Next paragraph. The receiver has also, we talked about mediation, so here we go. Here's the great explanation about the status of the mediation. And after this, you could tell me what you've learned from this paragraph. The receiver has also been engaged in mediation proceedings in an effort to resolve certain claims more expeditiously. I got to stop there. They could have resolved certain claims more expeditiously if they would acted with aggression from day one and gone after these same parties that they're now in mediation proceedings in months later without having done complete discovery. So when they reference they're doing it now to resolve certain claims more expeditiously, that makes no sense and is opposite to the facts here. The way they could have resolved certain claims more expeditiously is to go hammer and tong against these bad actors, according to the receiver and their various reports they spent thousands of dollars putting together from day one. Not, in my opinion, this would be my legal opinion, not, in my opinion, dicking around and waiting for them to capitulate. They're waiting for people that the receiver claims in these various reports to engage in all this misconduct to capitulate without any force. Makes no sense. It's not reasonable. It's kind of naive. You wonder why somebody would do that. Why? Now the counsel gets paid no matter what. They get paid, whether it works or doesn't work, whether the shareholders care or doesn't care. That doesn't give me a lot of pause, or actually it gives me pause. It doesn't make me feel comfortable that they're operating in the best interests of shareholders. So that being the case, nothing from this point in time is going to go unscrutinized. Nothing. I'm continuing on. Communications related to these mediation proceedings are privileged. That is correct. So mediation is a confidential proceeding you can't talk about. But we'll deal with that in a second. Which is common. Let me put it in context. Communications related to these mediation proceedings are privileged, which is common, as privileged communications foster settlement. That is true. So any kind of settlement proceeding is privileged. So what happens is, oftentimes, the mediator will prepare a document, and the document will say this is privileged, and everybody agrees not to disclose it, and everybody signs off, and you're subject to that document. And that works, and that stays confidential, and you can't communicate to the court, you can't communicate to other parties, etc. Everybody, all the parties know what happened, but it's not, you can't cite it anymore. So if somebody offers $1 billion and then you go to court, you can't in court say they offered me $1 billion. You can't say anything about it. Okay. So communications related to these proceedings are privileged, which is common as privileged communications foster settlement. However, this means that shareholders may not be present during these sessions, and the receiver is unable to disclose details of these discussions. I've practiced law for 40 years. I'm not aware of anything that prohibits shareholders from attending. They just would have to be subject to the same confidentiality. I've been in plenty of mediations where third parties attended and signed off. So unless this is some peculiar statute or strategy or technique in Nevada, this is just false. At least as in my understanding. If I wanted to attend a mediation and everybody was agreeing to confidentiality, I'd have to agree to confidentiality. I obviously couldn't participate in the offer and discussions like that, but I certainly, and my intention was to monitor the process so I didn't think that shareholders were getting shafted, and also to give at least the mediator privately a little backdrop as to why the shareholders might be pissed and why the senior management might think twice about being resistant to resolving the case. And in part, so this statement here, I don't believe, because I've seen third parties and had third parties attend just subject to confidentiality. So I just don't believe it. But anyway, there's some local Nevada statute or some contract document or something like that, but there is no reason that subject to confidentiality that somebody couldn't be there. And I would think I would have communicated to, and whoever wants to listen to this, I don't understand why senior management doesn't understand, because people have contacted me and told me this, that if they basically stonewall, that people are going to end up going to the Attorney General's office and the IRS to pass on their story and let the feds take them on. So why they're contesting this to make this a public civil proceeding to basically lay it in the lap of the feds to go after them, I don't get it. That makes no sense. I don't know if they think that if they can stonewall, that some way they miss out on this. I tend to believe that if they stonewall and there's not a resolution, there's going to be enough shareholders that are going to bitch at prosecutors and IRS agents and prosecutors that this will not end well for those parties. Now, Reichman's an old guy, and I think he was ill, so maybe by the time, and maybe he thinks that he will avoid that. But other parties who were implicated by the receiver and his reports may not be so lucky. So it's an interesting strategy to me that they have taken this approach and exposed themselves to what I think is kind of a silly exposure. But that's their choice. Anyway, moving on. So the receiver can't disclose the details. They can disclose that if the mediations are ongoing, they could disclose the next time they're having a mediation session. They can disclose if the mediation was successful or not successful. They certainly can put out an 8K to address that. If they think these are, see, here it is. Material non-public information can be expressed in an 8K. So if this is material, then why not express it in an 8K? If it's not material, then why aren't you disclosing it? Again, you can't have it both ways. Either you disclose it because it's material information that you can disclose, mediation was unsuccessful, resulted in a settlement, whatever, or it's not, and you should disclose it. But you can't have it both ways. The receiver's counsel seems to want to have it both ways. And again, be vague and not transparent, contrary to what they allege that they're intending to do. Continuing on. Foremost, though not required by the receivership order, the receiver will ensure that settlements and releases of claims against former officers and directors of the company will be subject to the approval by the court overseeing the receivership proceedings, and that the general terms of such release and settlement agreements will be posted on Edgar and the company's website. So they're saying that I don't know who's going to be the one who's going to be spending the money to object to the settlements, because think about it this way. If there's a settlement that's negotiated between the guys that the receiver claims are bad guys and the receiver's counsel, so are any of those guys going to be objecting to the outcome? So who's left? Who's left to object? Who's going to hire counsel and spend money? Of course, I might object, but the court's probably not, let's be honest, the court's going to be, it's a Nevada court, Nevada judge, probably going to be more receptive to local attorneys. So I think this is kind of like BS, another BS statement. They don't want to be called out. So they're going to let the court sanitize the settlement because they believe that if they present something that's anywhere in the ballpark of anything they claim to be reasonable and there's not super opposition, in light of all the circumstances, that the judge would sign off on that and that they would be basically immunized. And that's why they're doing it this way, my opinion. The risk they would have otherwise, if they did it without the court approval, then somebody could come back and maybe contest it, and that they might be exposed that way. So I don't think this is in the best interest, done in the best interest of shareholders or the company. It's done in the best interest and the sole interest, in my mind, of the receiver and the receiver's counsel. And again, probably results in further expenditures of money, additional expenditures of legal fees that only benefit the receiver and the receiver's counsel, not the shareholders. Last paragraph. And thank you for those of you who hung out for this hour. Thank you for hanging out. I hope this has been enlightening to you. Kind of how an attorney would kind of review something. And I hope it's enlightening to you as to concerns you might have had. And I hope it gives you energy and enthusiasm to closely monitor this as we continue through this process. Last paragraph. We understand the concerns shareholders have and remain committed to managing the receivership process fairly and transparently within the framework established by the court. I think that's BS, my opinion. I don't think they haven't been transparent. I don't think well, as far as I know, they haven't been fair. I haven't seen the bills, so I don't know if they've been fair and transparent. Well, certainly not transparent. I don't think this is transparent. And I don't think to this point, it's not been transparent. Just a used word, just like a word that's thrown out in an attempt to create a mood that they've acted appropriately. I think that the thing that is clear here, there's been a complete absence of transparency. And in fact, if you look at it, the receiver says he's not being transparent because he can't be transparent. So when you say you can't be transparent because that's the law, and then you say you're acting with transparency, I find that inconsistent. And I find it, makes me doubt the language that's used. Doesn't necessarily, again, make me suspicious about the ultimate outcome, but it makes me want to scrutinize the work product of the receiver and the receiver's counsel much more carefully, and also makes me want to scrutinize any future billings that are made. If you recall, even like the receiver's compensation that was set up based upon him receiving a percentage of monies that were recaptured, and he's recaptured some amount of money, let's say probably like $1 million, I think, which is not an insignificant amount of money. He got, I think, 10% of that, so it's like $100,000 or so, might be slightly less. That means $900,000 remained. That means $900,000 has somehow gone to, apparently, to either lawyers, mostly probably, and accountants. We don't know what's happening with the audit, so we don't know how that money's being spent. No explanation, no reference, no time frame, no nothing here as to that. But that money's been spent. So whatever they've brought in, they've basically spent. And if you recall, when the compensation scheme was set up, we weren't consulted. It was negotiated, and we certainly did not know the number of shares that were outstanding that could be reclaimed. And if in fact that everybody had been aware of that, perhaps the compensation setup would have been different, because then the question is, throughout, is the compensation of the receiver reasonable and appropriate, especially based upon the fact we weren't aware of all these shares, which he would get an interest in. And it wouldn't, and in the end, it wouldn't be appropriate if the person that makes out the best is the receiver and the receiver's counsel. That wouldn't be right for us. And I'm not going to just stand back and let it happen, nor should you, in a very civil manner. The last line: thank you again for your engagement. Sincerely, and it's not even signed. So it's not even sincerely by anybody. It's just sincerely, comma, blank. And then beneath that were all the prior emails that apparently weren't responded to. So I've kind of laid out their response. They didn't even have the balls to respond directly to me. They responded to another shareholder, obviously knowing that I would get it. They throw in stuff that I question the validity, credibility, accuracy of a lot that's contained in here, including that it's from the actually generated by the receiver. And they've indicated that they can't provide any material information, so this isn't material. It's not advancing our knowledge, doesn't give us any information. There certainly is stuff they could discuss that they have elected not to discuss, in my opinion. And, we just have to stay on top of them at this point in time, and as I will. And I'm going to scrutinize everything that comes from them from this point in time and from the receiver. And that was their choice. Again, I gave them numerous opportunities to just, keep shareholders in the know confidentially, didn't have to disclose anything. Just kind of give a general idea of what was going on. They elected not to. They elected to spend the money that was retrieved. And that's so be it. So we'll keep on top of it. We'll keep on following it. As far as I know, the AI-Versity stuff is still ongoing. And I know that they're interested in moving forward. If that deal doesn't go forward, I'm going to believe it's going to be based upon the actions of the receiver and the receiver's counsel, not AI-Versity. That's what I believe. And if that happens, I'll examine the possible remedies we have at that point in time. So that's where I'm going to leave you today. Hopefully it was informative. Hopefully you got information on it. Not trying to make you anxious or insecure, just to try and really bring you up to speed about what's going on, so there's no surprises. And that's so you have power to express yourself, intercede, express yourself to the receiver, receiver's counsel, etc. So for all of you out there, who hung out for the entirety of this, I appreciate it. Please share, comment, like. If you have questions, put them in the comments. I do look at all the comments, and I will respond to the ones if I can respond. If I don't respond, that means I don't have anything to add, or I can't respond for some reason, or I choose not to respond for some reason. But otherwise, I appreciate everybody. Thanks for hanging in here. Let's continue the GTII fight, and we'll talk to you soon. Okay, and have a great day, everybody, and be